after the presentation. So at this point, I wish to switch off my video and also now share the presentation. Kindly confirm you can see that.
Yes, that's
Yes,
okay.
we can.
So I can talk about myself. Varis already did that for me. So let me, sure. So I want us to do a brief introduction to intellectual property before we come to the specific questions which relate to um, innovators and micro and small and medium enterprises, which are in the space of innovation and particularly software developers. So intellectual property can be defined as a category of intangible rights which protect commercially valuable products of human intellect. This is a definition of the Black's Law Dictionary. What we pick from there is that intellectual property is intangible property. Traditionally, we have known of physical properties, but with time, intangible properties evolved, and currently, intellectual property is one of the categories of intangible properties, in addition to others like share certificates, which were very popular. Under the WIPO, the World Intellectual Property Organization handbook, they have defined, or they give a perspective of definition of intellectual property as the legal rights that result from intellectual activity in the industrial, scientific, literary, and artistic works. At least the WIPO definition is a bit wide, and it gives a category of the legal rights which relate to various activities, be it industrial, scientific, literary, and artistic fields. I trust and believe that the participants here are more inclined to software development. So you may be asking, so if my software is already developed, yeah, that is a property you have. It is an intangible property. It can be in any sector. It can be an industrially applicable software. It can be a scientific software. It can be a literary work, or it can be an artistic work. So intellectual property rights are broadly categorized into two, namely, we have industrial property and we have copyright and related rights. So industrial property is constituted of intellectual properties like patents. A patent is an innovation which is new, which has to pass the novelty test. It has to be industrially applicable, and it has to involve an inventive step. So if a creative has come up with something which is very new, which has industrial applicability, and there is an inventable step involved in it, then it can get protection as a patent. They are very common in the pharmaceutical industry. And then we have utility models. These are also called lesser patents because they are derivative works from a patent. They are easier to come up with and easier to register as opposed to patents. So the distinction really rise on the fact that a utility model is a derivative from an existing patent. Then we have industrial designs, and these constitute the aesthetic features of products. Normally, if you have a shape of a product, that shape can be protected as an industrial design, and the holder of that industrial design has the right to prohibit others from using that design. Then we have trademarks. Trademarks essentially are marks which indicate the origin of a product. So it associates itself with the manufacturer or the origin of a product. It can be a logo, it can be words, it can be figures, it can be combination. But ideally, a trademark is a mark which when you see, you associate the product with a given source. We also have geographical indications, which products which are associated with the unique geographical features or conditions of a particular area. The very easy example we can give is if you're talking of the rice in Mwea, which is called Shori, which has a specific, unique aroma. So that kind of product can get a geographical indication, production or protection and intellectual property, in the sense that the producers of that rice can come up together and as a group register a geographical indication, such that when you see rice coming from that place, you can know that it has the unique features because of the area, the geographical conditions where it is grown. Again, geographical indications are very common with wines and whisk, the alcoholic beverages, generally wine and whisk. Then we have another category which is of interest today, which is copyright and related rights. So copyright essentially is focused with protecting literary, artistic, musical, and audiovisual works. So we shall be talking of this later on in details, but at this point, it suffices to note that if you have a book, you have a film, you have a song, you have a software or a computer program, that one falls under the category of copyright. And then we have related rights, which are also known as neighboring rights. So these ones are the rights which protect performers, producers of sound recordings, and broadcasting organizations. They are called related rights because they don't exist on their own. They are pegged on the existence of other works. So these other works are copyrights. For example, if you are a composer of a musical work, then you need a performer. So the performer cannot say that he has a right in performance if there was no musical work composed by someone. The same to producers. You are an author. You've made your lyrics. Then you have approached a producer to produce the work, put in the melody such that you can produce a song. So the right the producer has will only be in existence because there was already a copyright existing somewhere in some work. So that is why they are called related rights. The same with broadcasting organizations, their broadcasts are pegged on the existence of other rights. So it is therefore important for us to understand that intellectual property generally is intangible property, and it is constituted of rights which are conferred upon a person who has created something out of their mind, and that it is categorized into two: industrial property and copyright and related rights. What is the legal basis for protection of IP in Kenya? We begin with the supreme law of the country, which is the Constitution of Kenya 2010, and Article 2(6). The Constitution provides that any treaty or convention which is ratified by Kenya forms part of the laws of Kenya. And one of the treaties which is applicable in intellectual property matters, particularly the ones of software development, is the Berne Convention together with the TRIPS Agreement. We will see others. But the fact that the Constitution of Kenya provides for recognition of international treaties, and Kenya is a party to the international treaties, particularly the Berne Convention and the TRIPS Agreement, that makes it a basis for protecting IP, because Kenya, being a member state to the formation of these treaties, is obliged to grant or implement the enactments or the provisions of these treaties. Similarly, under Article 11(2)(c) of the Constitution, the state, which is Kenya, has a duty to promote the intellectual property rights of the people of Kenya. So this includes copyright and related rights and software development and all the other intangible rights which fall under intellectual property. Article 45, 40 sub-article 5 of the Constitution also provides or imposes a responsibility on the state to support, promote, and protect the intellectual property rights of the people of Kenya. So if you come up with your software, then the state has a duty to ensure that that software of yours, which is an intellectual property right, is adequately protected. Lastly, under Article 69, sub-article 1C of the Constitution, the state, which is Kenya, is under duty to protect and enhance intellectual property in indigenous knowledge or biodiversity and genetic resources of the communities. Yeah, this is a duty on the part of the state. If your software is inclined to any of these areas, it makes it a relevant a constitutional. And I've not picked all of them, but I picked just three. The Copyright Act of 2001, administered by the Kenya Copyright Board, provides for enforcement and administration of all copyright and related rights matters. Then we have the Industrial Property Act, which again is administered by the Kenya Industrial Property Institute, known as KIPI, which is charged with all matters relating to industrial property. So in Kenya, we can say then that industrial property is governed by the Industrial Property Act of 2001, which is administered by KIPI, while the other category of intellectual property, which is copyright and related rights, is governed by the Kenya Copyright Board and provided for under the Copyright Act of 2001. Then we have the Anti-Counterfeit Act, which establishes the Anti-Counterfeit Authority. This essentially is an enforcement agency for any infringement which may arise out of industrial property. And it has administration which also prohibits piracy, and part of the mandate of the Kenya Copyright Board relates to anti-piracy activities. So it is an enforcement agency in cases where there is a breach of the other two legislations. So the main aspect we can pick from this is that intellectual property matters in this country are constitutional matters. They are not merely legislative matters, but they are constitutional matters. And the constitutional being the supreme law of the land, it makes it, it shows a very high level of commitment to safeguard intellectual property. These are the international treaties that govern IP. Generally, Kenya has not passed all of them, particularly the WCT, the WIPO Copyright Treaty, and the WIPO Performances and Phonographs Treaty, which is the WPPT. But the other ones are passed, and the very old one, the Berne Convention, in relation to literary and artistic works, is the one which was amongst the very first international legislative instruments in the area of intellectual property. So we may not really get into details on this. Let me take you to why you may have registered for this webinar. What is copyright? Because your software is protected under copyright laws in this country. So what is copyright? Copyright may be defined as the legal right which is granted to the creator of an original work to control how that work is used by others. So essentially, copyright applies when a person has created an original work and that person is given the right to determine how that work is used. It can also be defined as a property right in an original work of authorship fixed in a tangible medium of expression, giving the creator exclusive rights to use and distribute the work subject to certain limitations. So this definition brings out very key elements on what can be protected under copyright or what is copyright generally. For you to claim that you have copyright, you have to have an original work of authorship. Original, meaning you're not copying it from someone, you're not bringing us something which is already in the public domain, but you have created something which never existed before. That work must be fixed. That is the other aspect we can pick from here. Fixed in an tangible medium. For you to claim that this is my work, we should be able to clearly identify the work you are claiming to be yours. So you can't do that unless the same is fixed in a tangible medium. For example, if you have a poem in your head, we can't give you copyright. But if you wrote down the lines of the poem, then you can seek to get copyright protection over the same. If you have a song which you may not have written or you have done anything, but is within your head, you know it, you can't get protection for it. However, if you wrote the song, sang it in the public somewhere, then you can claim that this work belongs to me. And then the extent of use of copyright protected work is subject to limitations, meaning much as you're the owner, the author of this original work, and much as you have the right to control how it is used, there are some exceptions and limitations where you may not have control. For example, if your work is being used for purposes of news and sharing information about what is happening, you may not claim maybe right of infringement. But the very common limitation is that if the work is being used for a private purpose, someone is not commercializing it, then in that case, you cannot claim infringement, or you don't have a right to control or prevent private use of your work. So under Section 22 of the Copyright Act of 2001, the works listed here eligible for copyright protection: literary works, musical works, artistic works, dramatic works, audiovisual works, sound recordings, and broadcasts. So these various categories, any work which lies under this can be protected under copyright. If it is literary work, we have said softwares in Kenya are protected under literary works, but these literary works entail other works like books, novels, and related. Musical works, they're very easy. Artistic works, this entails maybe drawings, dramatic works, performances, audiovisual works which combine audio and visual, sound recording, purely sound recording works, and broadcast by broadcasting corporations. Important to note is that copyright protects the form of expression of an idea and does not protect the idea. So again, this is a common question from creatives. I have an idea. I want you to copyright my idea, or I want copyright over my idea. So the simple answer to that is that copyright does not grant protection to ideas. It grants protection to the manner in which the ideas are expressed. Remember, all intellectual property rights are negative rights. In other words, they create monopoly and they exclude other people from using their work without their permission. So it would be absurd to have a monopoly of an idea, whereas the same idea may lead to very many differently expressed works capable of protection. For example, if we were to say that the person who came up with the idea that money can be transacted through a phone, if he's the first one and we give him copyright over that, it means it stops anyone else from coming up with an app which can transfer money through the phone. But again, doing that is negative because you're stopping people from being creative. So with different kind of the same idea can be expressed differently through different um, maybe codes or maybe softwares, such that you have many of these money transacting mobile apps, but expressed differently. Secondly, it is important to note that copyright is granted to original creation. So originality is key. You can't get protection if whatever you're seeking protection over is not an original work. And that original work must be expressed, meaning it has been fixed in some form. Otherwise, how will we um, know what we are protecting? The expression here does not really have a specific form. It can be performed, it can be written, it can be in a drive, so long as it is possible to identify where the work is. And then the duration of copyright protection in Kenya is for the rest of the life of the author plus 50 years from the date of the death of the author. So at least you know now that copyright is basically the rights an author gets in creating an original work and putting it in a tangible form. And most important is that softwares are protected as copyright under the category of literary works. I'm emphasizing that because in other jurisdictions, they do not um, uh, protect softwares as literary works, but as maybe patents. Rights comprised in copyright. So when you have created an original work, you've made it into a fixed form, you have expressed it, what you get entitled to. There are two basic categories of rights you get as the author. The first one is economic rights, and the other one is moral rights. So the economic rights basically enable the author of the copyright to commercialize their work and get economic benefit from whatever they have created. And it also permits the author to exclude any person from using that particular work except with their permission. Remember, we said that all intellectual property rights are negative. They seek to exclude people or other people from exploiting the work. So we are saying if other people are permitted to use your work without your permission, they may end up getting more benefit than you, the author. So that is why under intellectual property law, the authors or the creators of the works are given this protection. So what can you protect against? What are the rights you get as an author? The first one is you have a right to reproduce your work. If you need more copies of the work you've done, that is the copyright holder's right. That is the creator's right. That is the author's right. Is the one who has the right to reproduce his work. He has a right to distribute any copies, the right of distribution. If you want to distribute your work to many other different places and different people, then it is your right. Public performance, it is your right to publicly perform your work. If it is a software and you want to have a demo of how it works publicly, then it is your right. You can choose to do it. You can choose to permit someone to do it. If your work has to be broadcasted or communicated to the public, it is your right to permit the same. Remember, subject to you not stopping the use of your work for information purposes like news. If your work requires or is capable of translation from one language to another, it is your right to permit it or prohibit it. If the work has to be adapted into another form, then you, the author, are the one who is the right to do it. So these are the rights or the economic rights of a copyright holder. So the copyright holder is the author of the work, or where an assignment has been done, which we will talk about much later, or a license has been given. We will talk about that. But these are the exclusive economic rights of a copyright holder. Then we have the moral rights. So these moral rights are not the same as economic rights because they are basically rights of attribution, the right to claim authorship, and the right to object to any distortion of your work. So the essence of these rights is that they seek to preserve the integrity or reputation of the author. This is very common with literary or artistic works or even musical works. You, as a creative, may object to your work being used in a manner that promotes ideals and values you don't associate yourself with. A basic example is you can object to the use of your song, maybe to promote uh, a product you don't support. For example, if it is an alcoholic drink and you don't believe in such. You may also stop all the use of your work if it is being used in a movie or an audiovisual work whose theme goes contrary to what you believe in. So generally, the moral rights seek to protect the dignity and reputation of an author. They may not be assignable, but in other jurisdictions like America, they assign even moral rights. But in most jurisdictions, and particularly in our country, we do not permit assignment of moral rights. If you have created the work, it is yours. You get the moral rights, they are not assignable, but you may assign the economic rights. Now, you're a software developer. You have created your software. How do you register it? Or how do you protect it? In Kenya, as we have already said, softwares or computer programs are protected as copyright under the category of literary works. It is very important for all of you to know that copyright protection is automatic upon creation of the work. So long as it is original, it has been fixed in a tangible form, that at that point you have copyright protection. Registration is not a mandatory requirement. You cannot be stopped from exploiting your copyright work on the basis that the same is not registered or on the basis that you do not have a registration certificate over your work. No, registration is purely voluntary. In Kenya, again, Section 5F of the Copyright Act mandates the Kenya Copyright Board maintain an effective database, data bank on authors and their works. So this is the basis on which voluntary registration is carried out by the Kenya Copyright Board through the link, which you can see there. It is called the National Rights Registry portal. So the portal enables the copyright holders to register, view, download, or copyright registration certificates from the portal. So the link is provided there for those who wish to visit it. But as I've said, copyright registration, including your software, is not mandatory. Registration is voluntary. And since we have not said more about the Copyright Board, there's a note there that the Kenya Copyright Board is a state corporation established under Section 3 of the Copyright Act, which is charged with the responsibility of administration and enforcement of copyright and related rights in Kenya. So those links were obtained from the website of that board. So how do you register? Again, if you go to the NRR portal, you will find this there, but the steps you got to follow include accessing the site, which is nrl.copyright.go.ke, using your computer or your smartphone or your laptop. Once you're there, you create an account and then upload your work. You can either create an individual account or a corporate account. After that, you will receive a validation code, enter the code, and complete the account creation process. After creating the account, then you log in and proceed with the registration. So, since you are all software developers, for registration of a software, you need a sufficient description of the software. You need to disclose part of the source code, which you think is the most important part. Then you need screenshots of how the system looks like and how it works. So with this, the Kenya Copyright Board is able to process a copyright registration certificate and have it sent to you via email. So take note of that link. It is very helpful since it is necessary for you to register your copyright works, although it is not mandatory. So why is it necessary that you register? Because number one, it acts as a public record that this is your work, that you are known that this is the work of so and so. It is evidence of ownership. As you commercialize your work, you wouldn't be telling people, I have a code in this disk, and it's the one I'm selling to you. And someone comes and says, I have a copyright registration certificate over this particular work. It is contained in this flash or this disk, and is the one I'm selling to you. So it becomes evidence of ownership, and it can even be used in the event of a court dispute. Similarly, there is a law which was passed in this country in 2017, the Movable Property Security Rights Act. Under this act, it recognizes that assets like the intangible ones like copyright can be used as collateral in a bank or to get a loan facility. So for you to use it, it will be necessary for you to have a document which is proof of ownership of the work before you can use it as collateral to get a facility. It is also easy to commercialize the copyright because you're going to license someone to use your code or your software, you're going to assign it. There should be a basis for the license, there should be a basis for the assignment other than just the code or the source code. It also necessary or important when an IP audit is done. If you're an ICT company, your IP portfolio is constituted of different IP assets. So when an audit is being done, you wouldn't tell them that we have this software which we have implemented, but then you don't have proof of it, much as it is yours. Yeah, it is a formality, but it is a necessary formality. So this is why it is necessary to register your copyright, although it is not mandatory to do it. How do you earn from your copyrighted works? How do you commercialize it? We already mentioned assignments and licenses. So in an assignment, you're selling, giving it up, and what you're giving up are your economic rights in the copyright protected work to the person you're giving it to. So an assignment is a transfer of the economic rights. We restricted ourselves to economic rights because we don't yet recognize assignment of moral rights. But again, the economic rights is where money is. So you don't have to assign a moral right which has no money, but the economic rights have money in it. So you're transferring your economic rights to another person. The assignment should be in writing, ideally, because how will you have proof in the event of a dispute that the work was assigned to you? You can transfer the entire your copyright protection work, or you can transfer or assign part of it. Again, if you're doing this kind of arrangement, a written document is necessary to indicate which parts are assigned, which parts are not. And lastly, once you assign your rights absolutely to another person, then you cease to have a right in the same work. So in other words, in assignment, you're giving up your work to someone else. Then there is licensing, which is another form of commercializing of your IP work. So in licensing, you allow, as the copyright holder, another person to use your software under specific terms and conditions, and you retain ownership. You are the licensor, is the licensee. The licensee is holding the software subject to the terms and conditions the same was granted to them. You, as the copyright holder, you retain the ownership of the work. Once the license period lapses or any event stipulated in the license agreement occurs, then copyright reverts back, the rights revert back to the copyright holder. What are the forms of licenses? There is a proprietary licensing where users have to purchase a license to use the software. Licenses may be either single user or multi-user. They can be perpetual or subscription-based. They can be per device or per user. This is what Microsoft Office is doing and Adobe Photoshop. Also, it can be an open source licensing with commercial terms, where maybe a software is made really affordable, but revenue can be gotten from a point where the same is commercialized, or where someone who is using it requires support and maintenance. You may do what? You may bill, or where there's consulting, or where they require you to customize for them. This is what MySQL Red Hat Linux is doing. Lastly, we have software as a service. So this is exactly what we're using now. We are using Zoom, and I am very pretty sure that Dr. Caroline and Crad is here, made sure that this meeting continues beyond the traditional 40 minutes by paying for it. So this is one of the ways through which you can commercialize your work. Now we move to software infringement. What is infringement? Infringement is basically where a person has used your software without your permission or without your authorization. We are using software and not IP because this webinar focuses on software. So your software has been used without your authorization. In that case, we say there is software infringement, or there is an infringement. So infringing acts can attract both civil and criminal liability. So they can be criminal offenses, they can be civil wrongs. Again, it is important to appreciate that if you are taking a civil route, in case of an infringement, you are basically seeking compensation for the unauthorized use in form of damages. Damages being monetary compensation for loss incurred or for the unlawful use of your software. But if you pursue the criminal approach, then you're seeking to have the person who infringed your software to be punished by either fine, imprisonment, or both. Under the Copyright Act, these are permitted to be concurrent. The fact that someone has taken a civil action against you in the event that you're the one who's infringing doesn't stop them from taking a criminal action against you. So what are the acts which constitute infringement in software? Unauthorized reproduction. Again, these rights relate to, these acts relate to the economic rights or the right from the economic rights. If you make any economic use, or if you act or your act contravenes the economic right of the corporate holder, then you are acting in infringement. So unauthorized reproduction, if you're making copies, you're reproducing them without a license or without the permission of the software holder, then that is software copyright infringement. Unauthorized distribution, again, the right of distribution, we said it is only the corporate holder who can sell, rent, lease, lend, or make copies. Using without a license. Yeah, you're using a software which requires you to have a license and you don't have it. You have a license for 1 year, but the term ends, you're supposed to renew. You fail to renew. So you're using it beyond the licensed period. That is infringement. Even if the earlier way to which you acquired rights of use of that software were lawful, the subsequent ones will also be lawful. Making derivative works from a software without the permission of the corporate holder, like adapting it or translating it or altering parts of the source code to create a new version, again, that is infringement. Circumventing TPMs, technological protection measures, such that you can make maybe reproduction, distribution, and use without the permission of the owner easy, is also an infringement. Lastly, publicly performing or displaying the software of someone without their permission is infringement. So what do you do in case of infringement? Your work is there, it has been infringed. So you should have evidence of infringement, maybe screenshots, copies of infringing copies, have them somewhere, save the URLs, have emails or posts from various forums where the same has been shared. This is necessary because you can't successfully claim anything, be it a civil remedy or a criminal remedy, without having necessary evidence. Then you should be able to identify the infringer, be it an individual or an organization. You should be able to know who is infringing your work, who is using your work without your permission. Is it an employee? Is it a reseller? Is it a domain owner? Because if your work is hosted in some website somewhere, there's someone who owns that website. You should do a cease and desist notice or letter, depending on what is happening. If the infringement is ongoing, or if it is infringement of a live event, you may not do this, but where necessary, you can do a notice to stop, or telling the infringer to stop the infringing activity immediately. Again, it is necessary because in the event that you go to court, you will be asked whether you gave notice, because you're not supposed to walk into court without first trying to resolve the issue with the other party. So it is a procedural legal requirement that a notice is issued. It is advisable that you engage an IP lawyer experienced in intellectual property rights, disputes, or any lawyer generally, to give you guidance at that point. You can file a suit to seek civil enforcement. Civil, remember we said you're seeking money as compensation, or if there are statutory, maybe fines which are provided in a statute, then the same can be granted to you. You can take the criminal approach by reporting the same to any police officer, to any police station. Remember, the intellectual property rights are private rights. these are property which are private property, and the first responsibility of ensuring that they are safeguarded, protected, and not unnecessarily infringed is on the copyright holder. So it is your duty to ensure that your work is not being used anyhow. It is like you have a car and you want to say that you don't have control of who uses it. It is you can permit the use of it, it is you can stop the use of it. If someone has damaged it, it is you to take action. The same here, that you should be the first person to take action in the event of a breach or infringement. Consider, it is important to consider alternative dispute resolution because it is faster, it is cheap, it maintains business relations, and in Kenya, the Kenya Copyright Board offers free copyright infringement mediation services. So it is necessary that you try that approach in the event of infringement to ensure that the dispute does not last for too long. Common mistakes to avoid in this industry of yours when you're having a software, make sure you're not pitching your software ideas without an undisclosure agreement. Remember, we said copyright does not protect ideas, it protects the manner in which the same are expressed. So if you have to share your idea with someone, then make sure that you have an NDA agreement with them, especially big corporations. When you're presenting an idea to them, maybe it is the ICT department, you want to tell them that you have a solution to one of the operations they have in their organization, make sure the same is protected by having an undisclosure agreement. Avoid making informal agreements on joint development of a software. We have had cases or have had cases where you start off very well, but when you get to commercialization stage, disputes arise. You start asking the two parties, now who owns what? This one says, no, this was my idea. I started it, I incorporated it. It is your word against the other's word. So it becomes difficult to solve that kind of a dispute. So it is important that you have a formal engagement or agreement where the two of you or three of you are going to be developing a software together. Also, make sure you have binding contracts for commercialization of your software. If you're doing an assignment, let it be written, as we said. If you're doing a license, let the license be so clear, especially on terms of commencement, ending, and any other conditions subject to continuance or discontinuance of the contract. Lastly, make sure you monitor possible infringement instances. It is your property. It is you who has the primary responsibility of ensuring that there is no infringement. And that marks the end of my presentation. Over to you now, Dr. Caroline and Clarice, for the Q&A. Thank you very much.
Thank you so much, Asante Sana. This has been a really, really interesting talk. More especially because I've actually done a copyright. I don't have a patent, but I have a copyright. So for me, this has been very interesting, and I've seen some of the questions that I would also have wanted to ask. So maybe I can voice the one that is very close to my heart. I think somebody has been saying. I think Jenna said that. Given that Kenya follows a common law system, is copywriting alone under the Kenyan Copyright Act sufficient? Okay, he's given quite a long comment about the Copyright Act is insufficient enough, considering the US has allowed software patents since Diamond versus Dyer, 1981. So what do you feel like, if, for example, I've copyrighted my written works, is it sufficient to copyright in Kenya alone, or am I exposed? If somebody else uses it in maybe in the US or in the UK, am I still protected?
Thank you very much, Carol, and for that question. As we have said, copyright and intellectual property rights generally are private rights, and that the first responsibility of taking an action rests with you. And we are saying, under international law, there is no legal requirement for protection or registration as a precondition for protection of your copyright. You get automatic protection once you've created your original work and you put it in a tangible form. The same way you may have a contract with a person in another jurisdiction, even in a different continent, and still succeed in taking action against them, is the same way you will succeed in taking an action against someone else who has infringed your work, irrespective of where they are. And also indicated that we have the Berne Convention, which binds very many countries, and the TRIPS Agreement, which recognize the rights of authors of works. So Kenya is a signatory to it. There are so many other countries which are signatories to the same treaty, and they are required to offer the same protection to citizens of other nations. So it is sufficient to register your copyright in Kenya, or not even to register it, but have proper evidence of ownership of the work, such that cases of taking action become easier. Thank you.
All right, thank you. I think also there's also, when you talked about the registration of software, there's something about source code, and I'm wondering if that cannot won't attract somebody else being able to take advantage of your software pathway. You said that you have to screenshot that and send a bit of your source code.
Sure. It is a valid concern, especially for software creatives who know that the source code is the software. And you're being told that the voluntary registration for you to have it is you have to give part of the source code. Now, as we said earlier, registration of copyright is not mandatory. We are only indicating that it is prudent that you register, much as it is not a mandatory. And who are these people registering? Are they people whom you cannot trust your source code? For example, in Kenya, it is the Kenya Copyright Board. Why are they registering? Because there is a law which enables them or mandates them to create a national rights repository, and they have done it. So is there really anything you can hide from a government entity? You may oppose the registration, but elsewhere, the debate of registration is actually ongoing. For example, regionally, the African Regional Intellectual Property Organization has operationalized the Kampala Protocol and voluntary registration and notification of copyright and related rights. Globally, yes, the discussion is also going on. The essence of registration is for ease of commercialization and to take count of the numbers and the kind of works we have, such that it is easy to know the contribution, the economic contribution of the creative works coming from copyright. So there are good reasons for the requirement for registration on a voluntary basis. But again, since we are saying we are registering as proof of ownership, and they're saying they want a source, a part of the source code. So will you claim that this is your software if you never shared part of the source code, which has now been infringed? It will be difficult. So creatives, in my view, should not worry about the registration requirement. I trust that when the government says we are having this platform for registration, they are not having a platform to steal the works of applicants using the platform. I really wouldn't think and imagine that a government agency will create a platform through which it is stealing the creative's work. Carol?
All right, thank you. Yes, Well, I mean, when we hear things like Facebook was stolen, you never know just how far somebody might go to just take a little bit of a code and change something and actually monetize it. So I think I'll open the floor for other people to. There are quite a number of questions on the chat. I think I can read the one from Alfred. Can you protect something that is AI generated? So for example, if you use AI to generate, maybe to write a book or to help you write some literature, can you copyright that?
No. The simple answer to that is no, because copyright protects the author. Who is the
Yes.
author? The author is a person who is able to create something which is new, which is original, and put it in a fixed form. So when the product you're talking about is AI created, so the question is, who is the author of an AI generated work? It is not the natural person traditionally as known. So
Correct.
copyright generally seeks to protect natural authors, but again, there are debates going on whether AI generated works can get copyright protection, but as of now, the answer is simply no, they don't.
Okay, I think Jerry also wanted to know the cost of registering copyright in Kenya. I think there are different structures. I think it wasn't very expensive when I copyrighted my book, but maybe you can give the breakdown and where somebody, maybe there's a link to where somebody can find out what the cost of registering your copyright is.
I believe that the Kenya Copyright Board is still doing it on a voluntary 100% free. I believe so. They gave an offer. They have not seen a notice of change of the offer to encourage people to register. But before that offer was given, registration was 100 Kenyan shillings per work per individual. It was 500 per work for a company, and for softwares it was 1,000 Kenyan shillings. So again, the cost is really negligible.
Okay. And is there age limit to registering? I think Akinyi Omanga wants to know, is there an age limit?
No, there's
I
no
think
age.
maybe what she means is in case your work has been out for a while, I believe that's what she means, not the personal age limit. Maybe in case you published in 1990, can you now copyright it right now?
Yes, you still can register right now for the simple reason that registration of copyright has always been not mandatory. It is your work, whether you registered it or not. So if you choose to register now, a work you created 10 years ago, you'll still get your valid registration of copyright certificate.
Okay. Clarice, any questions for Alex?
Okay, I had one, I put it on the chat. I was wondering, can a disclaimer stating that you're the owner of the work in place of an undisclosure agreement? Because sometimes it's difficult when you're pitching to these funders or these companies, it's difficult for you to go with a NDA and tell them sign here. So can you just put a disclaimer in your work and say that you're the owner? And will that suffice as just how the NDA works?
Wow. The traditional way in which an NDA works is that the two parties are signing, the person who is presenting and the person to whom the same is presented. The reason why the two have to sign is for ease of resolving a dispute if it arises. If you're claiming that I pitched to so and so and they used my idea and they have not paid me, they didn't have it, me who introduced the idea to them, then we have to have a reference point. At what point did you have this? So maybe that may not be possible, but your prior engagements with them can be used as circumstantial evidence in support of your claim. For example, you writing to them, maybe them confirming you indicating to them that it is presenting only, it is my idea, I wish to present to pitch to you for purposes of funding only, and I'm not giving up the idea to you. That kind of prior engagement and communication with them can be used in place of an NDA, so long as it sufficiently indicates that the idea was yours and you are only pitching to them for purposes of funding.
Thank you. There are some other questions I'm seeing on the chat. Jacob Ngumi is asking, in the current world of complex social media, how do we monitor infringement of rights?
Okay, so the digital evolution is come with advantages and disadvantages. It has opportunities, it has challenges. You can easily market your work, you can easily reproduce, you can easily distribute, but at the same time, it can easily be stolen. So the question is, how do you protect over the internet? Maybe the only way I can think of right now is use of TPMs. Ensure that your work is sufficiently protected, that there are technological protection measures which are encrypted in your work such that it is not easily stolen. But the easiest way you will know is if the work is being used elsewhere. If you are able to have a system which can tell you now so and so is using this app, or there is a trigger which you can get when the app is being used elsewhere and it is an address you had not maybe given permission for use, then that way you can be able to know. But it is a challenge really to monitor online, but it is necessary for you to monitor it.
Okay, there are two more questions. I don't know whether you touched on this. Joyce is asking what happens when you find out there's an infringement by an international organization.
The, the same procedure follows. Have evidence of it, determine ownership, who is infringing, do a cease and desist letter, and then if it is hosted somewhere in some domain, know who is the owner of the domain, and try to reach out to them. There is international private law for making international dispute complaints. They may not be effective, but you can explore them.
Okay, I think maybe I can also ask, so for example, if I have copyrighted my work as a book, and now I want to change it either to be a play or a movie, I need to apply for it to be copyrighted in the new format, or?
Carol, that is a good question. These are two different works. You have a book, that is a literary work.
Yes.
It has been translated and it has been adapted into a movie. So a movie is a different work. So this different work is an audiovisual work, which is capable of protection under copyright. These are distinct works and they can get distinct protections.
I see. Okay.
Yeah.
All right. I think we are just 5 minutes off before we close. I think we can take final reactions. I think there's something you talked about commercializing. So, for example, if my book is currently in stores, which other ways do you feel people can use to commercialize copyrighted work? Because compared to patents, I think patents you can do what we call franchising. But what other commercial ways can somebody who has copyrighted work, such as music? I mean, I know these days we have a lot of young people in the creative industry. How can they commercialize their work other than just being the holder of the copyright?
Okay. Ideally, the traditional ones are assignments and licenses. But with technology, you're able to do what you were traditionally doing directly through the online platforms. So you can reproduce, you can distribute, you can license using online platforms. So instead of the traditional ways, you can explore ways through which you can use the digital environment to commercialize your work rather than just traditionally producing and selling physically.
Yes, I normally see people tagging others. You know, you may use somebody else's content, but then tag them. But I don't know if that has a monetary way of getting a commercial, you know, from your creativity. Maybe what do you advise if somebody takes something I've developed online, like a skit, and then reshares it, and maybe they attract monetary gain for themselves, but all they did was tag me and say, okay, this was the original user. You see that, does that come with a monetary commission?
Or we may use the example of musical works. Someone has done a popular song, you know, not really popular, but just a song which is well known. You use it in your own maybe account in your own handle, and your own handle is a commercial handle, meaning that you get gigs for advertisement of other people's or other companies' products or services, and you
Yes.
use it to do that. So in that case, you're doing infringement because you are commercializing someone's work. So the red line, which should never be crossed, is that use this work in whichever way you want, but never use it to make money. The moment you start using it to make money, then you are infringing on the rights of the copyright holder. If your account is a simple account for just expressing ideas like mine, which is not commercialized, then that is fine. Post anything. But if it is commercialized account where I get gigs, I advertise through it, and then I'm posting your work, it means it is going to contribute to my portfolio and it is
Yes.
going to get me good clients. So I will have benefited from using your work. And for that, you should take action against me.
Okay. I think
Yes.
Clarice, we can take the final question before we.
Yeah, there are some two nice questions on the chat. Maybe we could take those as final. Anne is asking if one uses part of another's software source code with permission, what can they use to protect the emanating software?
So creativity is two-way. Creativity is original or derivative. Even copyright is not copyright alone if there is no related rights. There is an original creative, there is a derivative creative. What an original creative does is creates work which is very original and it has automatic protection of copyright. But then a derivative creative will create a new work from existing works. So they get distinct protection. They get distinct protection subject to the derivative work, not overly copying the original work or similar with the original work.
Joyce also asks, what about the case of pitching to possible funders who have attended your pitching event? When does one need an NDA?
You need an NDA before you share the idea, because you won't need the NDA after sharing. They will have heard it already. And we are saying in most cases, these are people with money, they are people you need to fund you, but then you may hesitate to require them to sign it before you pitch it. That is why we are saying be smart in your engagement with them. Let it be formal, maybe an email confirming, hey, I have this idea on this and this and this and this. I wish to pitch it with you on this day for purposes of funding only, but not giving up the idea to you. Then they can say maybe in response, sure, we can have that on this particular day. Whether they state that they won't disclose or not, they have already confirmed that the idea was yours.
Okay, I think we can sum it up there. I think Clarice, you can give a vote of thanks to Alex for agreeing to be our keynote speaker. It was a real honor to hear from him and tap on his expertise.
Yeah, Caroline, Dr. Caroline, I have one question.
Yes, okay, go ahead.
Thank you so
Identify
much.
yourself, please.
Yeah, my name is Monroe Dickens from AGS. Yeah, so I had a question. I think Alex has touched on a very crucial thing because right now we are planning to have a platform where we can disseminate information, and we are planning to monetize this material. So, for example, we have attended this webinar and we have this session recorded. What happens if I maybe take this recorded material and upload there for monetary gain, but I've not informed you? But at the same time, I think during the session, you're always notified that we are recording this session. So does that act as a consent, or do I still have to do it in writing to maybe our presenter before maybe I post this work? Thank you, and back to you, Dr. Caroline.
Okay. So at what point is consent granted? You indicating that we are recording the session is not the same as we are recording the session and we will share it in our platforms for anyone to access. That is different. So what the presenter has consented to is the recording, and the recording is not, in the mind of the presenter, going to be shared for purposes of making money. If you want to make money out of the presentation, ideally you should get proper consent from the presenter. The slides which I have used, for example, they are my copyright. I own the copyright in them because I put them together from various sources. So if someone wants to use them, then he needs to obtain my proper consent. Otherwise, I'll just keep quiet. I give you, you go share, then I'll sue you and you pay me. So maybe I know the concern is how to avoid liability. How to avoid liability is simple. Just ask the people who give proper consent for anything you intend to share.
Okay, Jacob, you have a question? I think this will be the final one since we had a hard stop at 1:30. Go ahead, Jacob, ask your question. Jacob Ngumi, are you able to unmute yourself?
Maybe he forgot that he has raised his hand.
Okay. All right. I think then, Clarice, you can give your final remarks.
Thank you so much, Alex, for agreeing to be our speaker today and for sharing your expertise on copyright and software applications. And we've learned about how to register our software. We've learned about copyright and how different it is from other intellectual property rights. And I'm sure everyone is coming out of this meeting with an idea on how they can protect their ideas, how they can protect their softwares, their books. So we would like to thank you for sharing your expertise with us. And to our attendees, thank you for staying with us till the end. I know we are way past the time, but we are glad that you attended, and we are glad that you all asked questions and it was interactive. Thank you.
All right. Have a good afternoon, and thank you for joining us. Please look out for more webinars on intellectual property.
Oh, okay. Bye. Bye, everyone.
All right, bye-bye.